Good morning, everybody, and welcome to this Kuits HR Breakfast. This is our third HR Breakfast Club of the year, and the second one in a row where we've been coming to you by webinar. And it's a shame that, again, we can't say hello face-to-face in our office. For those of you who haven't met me before, my name is Tom Fairhurst. I am a marketing executive at Kuits, and I'll be your host for the next hour. For those of you who aren't familiar with Kuits or haven't attended one of our HR breakfast clubs before, Kuits is an award-winning independent commercial law firm based in Manchester City Centre. The subject of today's webinar is managing redundancy plans, and I'll take you through the agenda for today shortly. So just before we start, I just wanted to talk to you about how we've been helping clients through this difficult time and how we have a COVID-19 task force, and just flag to you really our wider offering and what we've been offering some of our employment clients on top of work around furlough, redundancy, and getting back to work safely. And I won't go into this in too much detail now, but if you have any wider issues, please feel free to get in touch with the team. So moving on to today, I'm delighted to introduce you to our speakers for the day. For those of you who've been to one of our HR breakfast clubs before, these will all be familiar faces to you. The three speakers from our employment team, they are Kevin McKenna, who is partner and head of the team, Claire Treacy, who is solicitor in the team, and James Howarth, who's also a solicitor in the team. Just for wider context, if you can see me, Claire and James, and you can't yet see Kevin, he's currently winging his way to the Kuits office to join us on this call, having had a few IT issues at home this morning. I'm sure we can all sympathise with Kevin on that. So he will hopefully be here for his section a bit later on. Otherwise, it could become an interesting breakfast club. So the agenda for today's webinar, just after this, I'm going to quickly go through with you some ways to connect and a short piece of housekeeping. Claire and James are then going to look at redundancy and answer some questions and difficulties that may be faced around the redundancy process moving forward. Hopefully then Kevin is going to join us for an expert insight session. He's going to talk about redundancy around tribunals, and also some more information around returning to work and other key employment issues at the moment. And then it's going to be over to you guys for a Q&A where you can ask any of the presenters some questions you may have at this moment in time. So just quickly to flag that there's numerous ways that you can get in touch with us at Kuits on this list here. You can go to kuits.com at any time and find all these different ways to get in touch with us, whether that's by phone, email. On the website, we also have a live chat. And also just to flag that we have 3 social media channels, Twitter, LinkedIn and YouTube. The firm's regularly putting out regular insights, legal updates from across the different departments of the firm with a huge amount of content. So if you don't already engage with us through one of the social media channels, please go and follow us. And also with the newly introduced Kuits YouTube channel, the previous HR Breakfast Club that we held online, the recording for that is also on there. That was about managing the return to work. So if you missed that, you can go back and see that again. And then just some brief housekeeping as well. So like I said, the fourth part of this webinar will be a Q&A with our presenters. So please feel free at any time to add your questions. You should be able to do so. There should be a panel at the bottom of your screen, a Q&A button where at any time you can add your questions. And please feel free to do so as we go through the webinar. Send your questions in. This webinar is being recorded, so completely appreciate if you want to keep any questions anonymous. You don't have to put your name or which company you work for or where you're from. Please feel free to submit questions at any time, and we will save some time for them at the end. And also just to say that on the back of this webinar, there will be a follow-up email which will have all the contact details that we just showed you a minute ago. And it will also have a link to our mailing list, which again like our social media channels, we regularly have new, fresh content that we send out on a weekly basis through our mailing list. So if you don't already subscribe to that, we'd encourage you to do so through that link. And also, as well as that, there will be a link to this recording as well. So if you, for any reason, can't stay until the end, or you'd like to watch it back, or you have any friends or colleagues who you think might find this useful, the link to the webinar will be sent to you afterwards, and yeah, you can watch that back if necessary. So housekeeping introductions over. I'm going to hand you over to Claire Treacy, and her and James are going to give a bit of an overview of redundancy at the moment. Claire?
Okay, thanks, Tom. So as we know by now, the furlough scheme is being wound down, and so that now that we're in September, employers are now expected to contribute to 10% of their furlough staff wages, as well as to their national insurance and pension contributions. And as a result, we've found that we've been talking to clients more and more and advising them on carrying out restructures in their business, as well as carrying out redundancy processes. And the key to carrying out a fair redundancy procedure really is planning from the outset. So right at the beginning, when you think that you may need to make some redundancies, and that's because there are a number of pitfalls that employers can fall into at the various stages of a redundancy process. And I think that most often we see that employers rush to make a decision far too quickly about which employees it is that are going to be made redundant. And if employers do that, then that can completely serve to undermine any redundancy procedure that you do then carry out. So it's not only important that you carry out a fair redundancy process in relation to your employees that have over 2 years service because of the risk of an unfair dismissal claim, but also that you're careful with all of your employees because of the risk of any discrimination claims, which can be brought by all employees irrespective of their length of service. So these pitfalls are why we have put together the 6 difficult questions about redundancy, and because hopefully that will help you if you are planning a redundancy process, or if you are in the middle of one now. And the reason that we've chosen these questions is because we've just found as a team that they're questions we've been commonly asked throughout the last couple of months. So if we move on to we'll start with the first question. How do I establish the correct pool of employees? So it's crucial that at the outset of any redundancy procedure, you establish what the correct pool of employees is. Otherwise, you are potentially setting the company up for an unfair dismissal claim before any redundancy consultation has even started. So unhelpfully though, there are no rules set by the legislation as to what the correct pool of employees should be. But having said that, that does give employers flexibility when deciding what that pool should be, because it means that a tribunal will only look at whether it was a reasonable decision to create the pool that you did. Therefore, it's vital that any decision you make about pooling is carefully thought through, and that you do document your decision-making process as well. I think as a starting point to determine the correct pool, it's definitely worth considering what the actual reason is for redundancy. So is it because of a complete closure of the business, or just because of the closure of one site? If it's either of those two, then it's usually going to be appropriate to pool the employees, obviously, that work in that business or in that site that is closing. But if you do have multiple sites and it's just one site that's closing, you are also going to need to consider employees that work at your other sites that perhaps carry out the same type of work, as it's likely that they will also need to be put into that pool of employees that are at risk of redundancy. The other reason why you might be making a redundancy is because there's a reduced requirement for work of a particular kind. Now, if that's the case, you're going to have to look at what the work is that there's a reduced requirement for. So, for example, have you lost a project, which means that you're no longer going to need the same number of technicians, for example, that you've got in the business? And if that's the case, then you'll then have to go on to decide which employees it is that carries out that work. And that sounds quite simple, but actually that's where a lot of employers fall into some difficulties. And that's because there's a number of factors that you should and make sure that you consider in that type of situation. So, for example, you'd want to be considering any employees that have a split role. So, for example, do you have employees that for 50% of their time, they carry out the work that there's a reduced requirement for, and then the other 50% of their time, they carry out work that actually there's ample amounts of? Because the likelihood in that situation is that those employees will need to be considered in the pool of employees at risk of redundancy. But obviously, each case will turn on its own facts in that situation. You will also need to consider the role that employees actually carry out. So obviously, sometimes employees' contracts say one thing, but in reality, they actually carry out quite a different role. And if that's the case, you're going to need to consider what they actually do on a day-to-day basis, as opposed to what their contract says. It's worth bearing that in mind, as well as if you've got employees that work at numerous sites, you will need to consider whether you've got employees carrying out that same work at the other site. Even if there's ample amounts of work for them at that other site, if they're carrying out the same type of work, they will probably need to be put into the pool of employees at risk of redundancy. So I said at the beginning about making sure that any decision about pooling is properly documented, but that applies to all stages of the redundancy process, not just pooling. And the reason I say that is because of, or mostly because of subject access requests. Because they can cause quite an issue in redundancy procedures. Many of you have probably had to deal with or respond to subject access requests from employees before, and will know that they are quite difficult to deal with sometimes and can be very time consuming. And in a redundancy context, sometimes it means that employees get their hands on emails or documents that perhaps you wouldn't want them to see. As part of the subject access request, they will be entitled to any internal emails or documents that identify them. And sometimes that means that they see internal emails which either suggest or just outrightly say that the decision to make them redundant has been predetermined. So you should obviously definitely be careful about what it is that you're putting into any internal emails. And it's going to be far better for the business if, instead of having those emails which would put you into hot water, is to have a document which shows that at the time of deciding the appropriate pool or whatever stage of the redundancy process it is, that you properly thought out the decision behind it, and that you're able to document why you made the decision that you did. So I'll pass over to James now for the next question.
So the first difficult question I'm going to cover today is whether it's possible to use subjective selection criteria when selecting employees for redundancy. So although there's no mandatory procedure laid down by statute in Great Britain, what case law has established is that redundancy selection criteria should, as far as possible, be objective rather than subjective. So objective criteria includes things such as attendance records, disciplinary records, and length of service. Length of service has its own difficulties, and I know Claire's going to touch on that shortly. So they're all objective criteria. Employers can attach different weightings to each of these criteria, reflecting the relative importance of that criteria to the business. However, you must always be able to justify the reasons why you selected that criteria and you've put that weighting to that criteria. So the reason subjective criteria is not used is because it's often very difficult to evidence any subjective decisions, and that leads itself open to personal bias and abuse. And if you get the selection criteria wrong, and it's unfair, then what naturally follows from that is an unfair dismissal. So some examples of subjective criteria are using things such as which employee is best suited to the needs of the business moving forward. So that has lots of difficulties in it, in terms of how do you assess what the needs of the business are moving forward. That's by its nature very subjective. And then how do you possibly assess an employee in terms of what skills they have now that could potentially translate to that future need. So that by very definition is a subjective criteria that I think would be very difficult to try and to use fairly. Other examples I've seen are employers using criteria such as positivity and attitude. Again, very much by definition, subject to kind of personal interpretation. What I'd say about that is that's different than any kind of disciplinary records that might follow from that. If you have disciplinary records, then maybe that could be objective, but purely just using that as a selection criteria is subjective and, again, probably unfair. Finally, what case law has shown us is using something like, if we dismiss somebody, they'd have the least detrimental impact on the business. That, again, is subjective and can't be objectively applied. That being said, subjective criteria may be acceptable if you apply it objectively. So what does that mean? If an employer can demonstrate that they've understood the criteria, they've understood the reasons why that criteria has been chosen, and that those that assess that criteria are qualified, are suitably qualified to assess that criteria, then it may be fair, even though it is a subjective criteria. So the example I'll give is from the case of Howard versus Siemens Energy. And in that case, they used the criteria company values, and they assessed employees on that basis. And that, by definition, again, is a subjective criteria. However, in this case, it was found to be a fair criteria to use. And the reason is they could point to actual company values. They were part of the company's charter. It was very clear and obvious what those values were. They then managed to put a system in place that assessed employees objectively against those criteria. So that's a subjective criteria that they've applied objectively that was found to be fair. So although I think objective criteria will always be easy to defend at a tribunal, I think the most important thing is any criteria that you use needs to be assessed dispassionately and objectively. The final thing I'll say on selection criteria is, if you do decide to use a subjective one, make sure you document the reasons why you've chosen that and how it's going to be applied, because it could become very relevant if it were to be challenged later at tribunal.
Okay, so as James has said, it is vitally important that a fair selection criteria is used when selecting employees for redundancy. For obvious reasons, many employers want to use length of service as a selection criteria by positively awarding points to employees that have been with the company for longer. Using this criteria obviously rewards loyalty and maintains stability in the workforce, and that is something that the tribunals have recognised. However, whilst it is possible to use this criteria, it should be used with caution because of the risk of an unfair dismissal claim for failure to use a fair selection criteria, but also because of the risk of an age discrimination claim by treating your younger employees less favourably. And that's because generally employees that have been with businesses for less time will be younger and therefore will be marked down in this criteria when compared to their older colleagues. So if you are going to use the criteria, that is fine, but it should you should be used with caution. So you should make sure that you don't use it, first of all, as the only criteria. It used to be the case that businesses did used to just use that simply as the only one, but now it's widely accepted that it will be only fair to use it alongside other appropriate criteria. You should also consider giving it a low weighting if you are going to use it. So that means that less importance will be attached to the score. Or alternatively, you could just use it in a tie-break situation. So if you've got two employees that have scored exactly the same, then you might award, and it would be appropriate to award an additional score to the employee that's been with you for longer, which would mean that their job is then saved and the employee that's been with you for less time would be made redundant. I think if you use length of service in this type of way, then it's going to be very difficult for an employee to dispute its use and say that that wasn't fair. And actually, we found that employees are quite receptive to that and are actually understand why you are using that criteria and actually expect employers to use it in some kind of way, and a tie-break way does seem to be the fairest way. I'll pass back to you, James, now for the next question.
So the next difficult question I'm going to cover is, what does the duty to consult actually mean? So consultation is fundamental to the fairness of any redundancy dismissal. If you fail to consult, it's likely it's going to be unfair any future dismissal. So ACAS defines consultation as a talk with employees and their representatives about planned changes, whilst also seeking their input and views. I think that's a fair appraisal of what a consultation is. However, the precedent case of R versus British Coal gives us a much fuller explanation, and I'll just read an extract now. So in R versus Coal, it explained that fair consultation involves giving the body consulted fair and proper opportunity to understand fully the matters about which it is being consulted, and to express its views on those subjects, with the consulter thereafter considering those views properly and genuinely. So there's a few key things to take away from that. What it shows is, as an employer, you must go into a consultation with an open mind. It can't be a fait accompli. The decision to dismiss cannot already have been made. As an employer, you must still be capable of influence. So as part of the duty is that when you're speaking to employees and consulting with them, you seek what their views on the redundancy are. You can't just dismiss those views out of hand, you must consider them. And finally, consultation must happen at a formative stage in a redundancy process. You can't decide to dismiss and then try and consult afterwards. I suppose what follows from this is that all employees must be given sufficient information to enable a proper consultation, and they must also be given enough time to enable the consultation to take place. So, what does a proper consultation look like? So if you're proposing to dismiss 20 or more employees at one establishment over a 90-day period, you're under a duty to collectively consult. And what that means, amongst other things, is that you have to appoint employee representatives. You then consult directly with those representatives on behalf of the 20+ employees. If you're proposing to dismiss less than 20 at one establishment over 90 days, then you can directly consult with the employees. You don't have to go through a third party. In terms of what the consultation should cover, well, it's an opportunity really for an employee to be consulted on the basis of their selection. So that might include consultation around the selection pool applied or any selection criteria that's been applied to them. It's also an opportunity for an employee to challenge their selection for redundancy. You should also listen to any suggestions that an employee has in terms of avoiding compulsory redundancies. And finally, you must consider any alternative employment with that employee. It's worth noting that that duty to consider other employment lasts until that employee is dismissed for redundancy. It doesn't just last the consultation period. So say, for example, you've got an employee who's been employed, who you've given 4 weeks notice to dismiss, which you're allowed to do under his contract of employment. And then 3 days before that notice period expires, another vacancy comes up in the business. You then must consider that employee for that vacancy. It doesn't mean he's going to get it, he or she's going to get it. It just means they must be considered. So the final thing I'm going to touch on duty to consult is around timings. So there's no prescribed timescale you must follow in terms of the consultation period. However, the general rule of thumb is, if the shorter the consultation period is, the more likely that the dismissal is going to be unfair. So I suppose that is always going to be the case unless you can get agreement from employees at the start of a redundancy process. So if you put together a proposed schedule and you put it to the employees at the start and they agree to it, it's going to be a lot more difficult for them to then challenge it later on. So what does that mean in terms of timings then? I'd say it's not unusual to see consultation periods taking between 1 and 2 weeks, obviously dependent on number of people affected. And finally, what I'd say is it isn't unusual to see at least 2 consultation meetings as well. So I'll pass you over to Claire now for the next question.
So next question is, what should I do if an employee refuses to engage in the consultation process? So it's important that all employees at risk of redundancy are consulted with. So that means any employees on maternity leave, sickness, long-term sickness absence, as well as on furlough leave must be consulted with. And failure to do that will, without a doubt, lead to an unfair dismissal claim. However, this duty only becomes problematic if the employees refuse or just don't engage with you for whatever reason, because obviously we can't force employees to engage with you. An employee might not engage with you because they are absent from the business and they just don't respond to you for whatever reason, or an employee outrightly says to you that they don't want to be consulted with, perhaps because they think the decision is predetermined and so they just see no point. If the employee is absent from work and they're just not responding to you, then it's important that you try to contact them by all communication methods, so using their work, email and phone, as well as their personal, as well as writing to them. And that's going to then make it very difficult for an employee to later argue that you haven't tried to consult with you, because you'll have that paper trail to back up your attempts. If you've made all reasonable attempts, the employee still doesn't respond to you, then I think it'll be very difficult for a tribunal to penalise you for carrying on the redundancy consultation in their absence and without their engagement. What I would do though is just make sure that you continue to update them by multiple communication methods at each stage of the consultation, just to let them know what's happened, and also that they are able to engage with you at any time. All they need to do is get in contact with you. If, however, though, the employee says to you that they don't want to engage in the consultation, perhaps because they think it's predetermined, then I would obviously acknowledge that, but make it clear to the employee that that's not the case at the outset of the redundancy process. It's only a proposal, no decisions have been made yet, and that they are able to engage with you, and that if they do, they could change the outcome of the redundancy process. If after you've tried to encourage them, they still refuse to take part in the consultation, then I would just let them know that you will continue without their engagement, but that you will update them, so perhaps emailing them at every stage just so that they know what's going on. And again, that if they want to engage with you at any time, if they change their mind, then that's completely fine. Again, I think it's going to be very difficult in that situation for a tribunal to penalise you for that decision, because at the end of the day, the tribunal will recognise that you need to carry on with the redundancy consultation process. I'll come back to you, James.
So this is the final difficult question that we're going to cover today, and it's one, I mean, I've been asked certainly a few times, and I think we have as a team been asked quite a lot as well. So the question is, do employees need to be given the right of appeal against a redundancy decision? So I suppose the answer in short is no. There is no statutory right to offer a dismissed employee by reason of redundancy the right of appeal. The reason for this is, and case law has shown us this, is a proper consultation obviates the need for a right of appeal. And what does this mean? Well, this means that if you've done a proper consultation process, you should have already dealt with any concerns that an employee had during the process. Therefore, there is no requirement to have a right of appeal. There's nothing further to discuss. However, I suppose what follows from that is, if you haven't followed a proper consultation process and you haven't offered a right of appeal, then there's something procedurally wrong, you've done something incorrect, then that could lead itself to an unfair dismissal. Therefore, I think it's advisable that you do offer a right of appeal for any redundancy dismissal, because it gives you the opportunity to rectify any defect that may have occurred earlier in the process. You would obviously be unable to do this once it gets to tribunal. It's also worth noting that the ACAS guide does suggest it's best practice to offer a right of appeal, but obviously by its very nature, that is just guidance. There's two further reasons that I do think you should offer a right of appeal, both in an employer's benefit. The first is offering a right of appeal, just by its very nature, lends itself to the idea of fairness. You're giving an employee an opportunity to raise any concerns that they may have during the process, and you're going to try and address them as well. Again, it just seems a lot fairer if it were to be looked at by a tribunal. Secondly, and I suppose slightly more importantly, it does tip you off as an employer as to any possible concerns, issues that an employee might have in the process. If you're tipped off before a tribunal process, it lets you counter whatever those concerns might be. So I do understand that offering a right of appeal in all cases is quite a big endeavour. Having somebody else look at the process, re-interview employees, it's quite a big administrative burden. So especially if you're a business that hasn't got the resources to kind of do that, what might be a decent halfway ground is effectively offering a right of a mini appeal. So what you could do is offer to an employee who's been dismissed the right to write to the dismissing officer, setting out what the concerns are with the process. Although it's not a full appeal, it just lets the dismissing officer know what potential issues there might be with the process. It also allows them a limited right to kind of counter whatever issues there might be without going through a full excessive right of appeal. So that's it for the kind of difficult questions now. I'll now hand you over to Kevin, hopefully he's here, and then he'll go on to his bit as well. So thank you very much.
So thank you, James. Hopefully people can hear me. Maybe a member of the panel could just nod if you can, because you can't see me, and so apologies for that. And that's because of some technical difficulties, which I won't try and explain because I don't understand, which means that my camera doesn't work. So I'm afraid you'll just have to put up with my brummy tones for this section of the talk. I just wanted to start off, I suppose, by summing up some of the broad issues in relation to redundancy cases. I suppose taking a slight step back in relation to those areas where I say why employers should never lose redundancy tribunal cases, why employers do though lose cases, and what is the cost, what it costs, it should say, to get wrong, and then how you get it right. So starting with the first of those points, why employers should never lose. The reason I say that is because where you are in a redundancy situation, then the law has teed it up for you as the employer in that redundancy is a fair reason for dismissal. So you've started off with something which should be a slam dunk reason, fair reason for dismissal, which is a good grounding in any potential dispute. We're also in circumstances where it is more widely accepted that there are redundancy situations. We only have the furlough scheme because it is so widely recognised that without it, many employees would have been laid off, jobs would have disappeared. So the economic conditions point towards it. There are also limits on the tribunal's powers, and tribunals are not entitled to substitute their views for the views of an employer. They can't say, well, I wouldn't have dismissed in these circumstances, and that's well established. I've had that from cases such as Foley in the Post Office and Midland Bank and Madden. So even if the employment judge might not have taken the steps that you did, that should not put you in any difficulty as the employer. And thereafter, it's about process, and there are processes to follow in those guidance. So in theory, an employer should never lose a redundancy case. Why do they lose? Well, very often because it's not a redundancy. In some situations, you've got to look at the definition of what redundancy is, and sometimes people can use the term redundancy too generically, that for redundancy, they just mean that they want to terminate someone's employment. So you've got to get that bit right. You've got to get the parts that Claire and James have talked about right. The key areas are pools, selection, process, and things like alternatives. And so if the word bumping means nothing to you, then that's an area where you're likely to fall down, that you won't have thought about those processes and how and the sorts of questions that employers must ask themselves before they finally reach a decision on dismissal. That's not to say that bumping is the only issue that you need to be aware of in terms of alternatives, but that's often just a good indicator of if that's not a term that's familiar to you, then perhaps this is an area where you need to get some guidance from a solicitor. What it costs to get wrong? Well, you'll of course be aware that there's potential for compensation for unfair dismissal and for protective awards, which Claire and James will have mentioned. But a growing area, certainly that I'm seeing, is discrimination, and that's often as a result of the selection. We've heard Claire talk about that. Some of those things are just about getting the selection processes right. Some of them aren't. Some of them, and I'll give you an example to illustrate what I'm talking about. I was assisting an employee in a disputed redundancy situation. He believed that the reason he was being targeted was because he was the oldest person in the group, in the pool. He alleged age discrimination. The experienced HR director said, and it was in a noted consultation meeting, that's a very serious allegation, Mr. Smith, Mr. X, whatever. If you're going to make an allegation like that, you're going to need to back that up with evidence. Well, that actually demonstrates a bit of a misunderstanding around the burden of proof in discrimination cases. And in fact, it's mistakes like that which actually gave rise to there being a termination payment and a settlement for that individual of 4 times the amount that he would have otherwise have been entitled to had they understood issues like age discrimination and burden of proof. So you've got to understand those costs, and that discrimination cases and those issues can increase the award that you might have to pay out. Of course, there's a potential for the legal costs, and one of the reasons why we think it's so important to get these things right now is that it is inevitable that you will be dealing with these processes at a time when you are trying to reduce costs, and it will be completely counterproductive to that aim to find yourself in a situation where you may then be in dispute with a series of employees or past employees because of getting it wrong. Actually, you can extinguish any of the cost savings or lots of the cost savings by getting it wrong. Reputation is an unseen cost in these things, and when I compare the landscape now to 2008, when it was the last time that there was an uptick in redundancies, there wasn't then the tribunal portal setting out cases and decisions. And so reputationally, they do become a bigger issue now that all cases where there are decisions are published on the tribunal websites. So that's something that employers need to be aware of. It just makes the stakes a little bit higher. So if you just go on to the next slide for me, Tom, I think there are a few issues that I think are just worth having in your mind. And I think that these, again, this is the sort of thing that we're seeing a lot, more issues, as you might expect, in relation to refusals to return to work and the situation about can you dismiss. Well, in the ordinary pre-COVID world, a refusal to carry out the managerial instruction of coming to work would typically be enough to at least found the basis of a fair dismissal. But I think that employers need to think differently about that at the moment. And it's not to say that the law has changed, in that failure to observe reasonable managerial instructions can still be an issue of conduct, but you just need to be more careful as an employer, and there are other protections that I think come into play. I mentioned one of them there, which is Section 100 protection, which is Section 100 of the Employment Rights Act, which provides protection to employees in health and safety cases. And at the mere mention, I suppose, of health and safety, you'll get the direction of travel that if employees are raising issues of safety, circumstances of danger which the employee reasonably believes to be serious and imminent, and which could not reasonably have been, they couldn't reasonably have been expected to avert, that they leave or that they refuse to return to work, there is protection for employees for that. I was also speaking to somebody just last week in relation to a case that had been heard in the tribunals in London, where quite rarely an interim relief claim had been made for someone who was dismissed in those circumstances, and it was granted. And that, what that means in practical terms is if you are an employee that's been in that situation, you have refused to return to work because of danger, health and safety dangers, then you can be awarded by the tribunal your continuing pay until the hearing takes place. Now that's a hearing that's been listed for a year's time, and that happens to be someone who's on a high salary. So there are cases like that that employers need to be aware of. You need to be aware of the issues that there are around vulnerability and disability, and generally in relation to indirect discrimination, because the circumstances of the virus and everything that relates to it actually brings into play lots of protected characteristics. Statistically, men are more likely to suffer or die from the from COVID-19 than women. People with an underlying health condition are more likely to be adversely affected. It is more likely to affect people dependent upon their ethnic backgrounds. Older people are more at risk, and people who are pregnant are regarded as clinically vulnerable. So if you transplant those protected characteristics back into the world of indirect discrimination, then requiring people to work from a workplace will be what the law calls a PCP, a provision, criterion or practice. And if an employee can say, or a worker can say, that that provision, criterion or practice, that requirement for me to work from the office has an adverse impact upon me because of my gender, my condition, my ethnicity, my age, my pregnancy, then on the face of it, that's potentially indirect discrimination. Now, employers can respond to that if they have a legitimate business interest, if they have a legitimate interest and a proportionate means of achieving that legitimate aim, But those are the sorts of questions that employers need to go through. They need to think through before you start heavy-handedly perhaps saying to employees, well, you've just got to return because that's what the business needs. You just need to be aware that there are rights which would protect people expressly in these sorts of situations. It doesn't mean that they're insurmountable, but it means that they need to be thought through, and they very often need to have been considered as part of risk assessments. So those are areas which I think we're going to see more and more of. Again, from speaking to members of the judicial community, what they're saying is that employers will be heavily scrutinised where they say to employees that you must return to work, perhaps even where they've been working from home, albeit the circumstances might have been different for the previous 5 months. You've got to recognise that that's the new playing field that you're dealing with when you're dealing with the employees who are going to be raising these sorts of issues. So we've created a package. It's actually something that I approached insurers about in 2008, which is to say, where employers have got a genuine redundancy situation, where we assist them then through that process, then would insurers be prepared to back that and effectively guarantee that process, so that if there were tribunals that came from it, that the insurer would pick up the tab in relation to legal costs and awards. And we have that in place where we have assisted and effectively held the client's hand through that process. It means that we can fix the cost for assisting you through the process. It means that there is a fixed premium, and then if there are tribunals, then they're covered. You might ask the question, well, if we've assisted through a process, what need is there of that? And my answer to that is, actually, the way that the landscape, again, if it's anything like 2008, is likely to go, is that there will be those employees who don't have strong tribunal cases, but who will nevertheless bring claims because it's all they can do. They may be staring down the barrel of a potentially long period of time out of work. And so people will be entitled to bring weak claims as well as strong claims, but that's a distraction for employers. And in a situation which I think I mentioned just before I cut out before, when you're trying to reduce costs, when you're trying to increase some certainty, when there's very little certainty around, then we think that this is something which offers employers some certainty. It caps your cost, caps your risk, and gives you some peace of mind, I think, for businesses moving forward.
We will just go to some questions. So, Claire and James, not to put you on the spot, both of you, but let's have a look at what has come through so far. The first question, do consultation meetings have to be held face-to-face?
I can take that one if you want, Claire. Well, I suppose the time we're living in now, the fact we're obviously living in a lockdown world, a post-lockdown world, I think it's more than reasonable to hold such kind of consultations by video call, even by telephone. What I'd say though in either of those circumstances is just seek the agreement of those you're consulting with, because if they agree to it, again, it's very difficult for them to challenge it after the event. So yeah, certainly video calls. I think we're seeing a lot more of that now in terms of doing those consultations. But yeah, seek agreement first, I think, is probably the best way of doing it.
Okay, great. I hope that answers the question there. The next one that we've had come in slightly earlier, how do I calculate the statutory redundancy payment for an employee that has been furloughed since April?
Yeah, I can take that one. So at the end of July, the government did actually introduce legislation to clarify that point, because they didn't want employees that were furloughed to be penalised by the fact that they had been made redundant whilst they were furloughed. So that legislation confirms that you have to calculate their statutory redundancy pay based on their usual full pay as opposed to their furloughed salary. Obviously, for employees that have an annual regular salary, that will be quite easy to do. But for employees that are have varied hours and varied pay, then that will be slightly more difficult. But the government have clarified that the way to calculate their week's pay is the same way that you calculated their week's pay when working out what their furlough pay should be, but obviously without that furlough cap. So yeah, hopefully that answers that one, but the government at least did helpfully give clarity on that point.
That's great, thanks Claire. I have another one here. And just to say, if you do have any specific questions for the guys, please feel free to add them in the box at the bottom of the screen now. So the next one, can employees on furlough be made redundant first?
Yeah, I can say that one, that's not a problem. So again, I think again, the more straightforward questions here, the answer really is no, really. So you shouldn't necessarily treat an employee who's been on furlough differently. You still need to go through the same fair process that we've been talking about. You've got to go through all the selection process, the pooling. In terms of that, it effectively doesn't make a huge amount of difference, the fact they're on furlough. But that being said, I suppose there's almost an inference from the fact you're on furlough that there's a requirement to do less work, almost, the fact that you're not needed to do work. So I suppose the answer to it really is, if you're on furlough leave and there is a genuine redundant situation, something that Kevin was explaining, making sure you get that definition right and understanding right, then I suppose it does naturally follow that somebody on furlough might be in a redundancy situation as such, and then therefore could be made redundant. But to answer the direct question, as a general rule, just because they're on furlough doesn't make them any more likely to be made redundant automatically, some kind of automatic criteria. It just doesn't mean that, unfortunately.
Okay, that's great. Thanks, James. Let's go to the next question we've received. Is it possible to consider the cost of an employee in a selection criteria? For example, if an employee earns more than their colleague, is it possible to score them down for this, as it will be cost saving to the business?
Yes, you can use the cost of an employee as a criteria, but like I was talking about with length of service a bit earlier, it definitely can't be used as the only criteria. And again, I would suggest that if you are going to use it, that you give it a fairly low weighting so that too much importance is not attached to that. And the reason I say that is because there is some risk with using the criteria because of a potential age discrimination claim, just because generally employees that earn more and therefore might be marked down are potentially going to be your older employees that have maybe been with the business longer, or obviously just got more experience. But having said that, I do think that tribunals will acknowledge and do acknowledge that it can be a great cost saving to the business, and that, for example, if you were to make one employee redundant that earns more, that might save the job of 3 employees, for example, that earn a lot less. So I think the tribunal will be able to see, hopefully, the justification behind why there might be some age discrimination there, provided that you've used it in the correct way, so alongside other fair criteria. I think just one thing to be aware of, though, is that as part of the consultation process, like James spoke about before, obviously you need to be discussing all alternatives to avoiding redundancy with the employee. If the more expensive employee says that they would be willing to take a salary reduction to avoid their redundancy, then you would have to take into account what their reduced salary would be if they were to get a salary reduction when deciding if they should be made redundant or not.
Great, thanks for that, Claire. And we've just got a couple more here, again on redundancy. One is, can you clarify the different sites or separate establishments in determining pools? I thought the Woolworth case changed that, even if to carry out the same job can be treated as one establishment. Is it down to what is defined as an establishment VRS site?
I can pick that up if you want. Yeah, it's not a problem. So yeah, I'll give a quite short answer to that, because it is very fact dependent, really, and what the circumstances are. But yeah, it is about determining what an establishment is, and there's lots of different factors in terms of what an establishment is. So something like that, you would very much advise seeking specific advice from us just to understand what it is. But yeah, I suppose essentially you can have people with the same job role, but in different establishments, being in different pools. But again, yeah, very much would seek specific advice on that, because it can get quite technical and complicated.
Yeah, I think it's just worth saying that Woolworth case is in the context of collect the numbers for collective consultation. So it was about determining how many proposed redundancies there are in the case of collective consultation. So that said that you only need to look at each establishment as opposed to the business as a whole. But the pooling that I was talking about before was in the context of deciding appropriate pools of employees, and that does mean you need to look across sites, so they're 2 slightly different angles of redundancy.
That's great, thanks guys. I hope that's answered that question. And we have one other here as well, and it's asking about some further detail on a single role redundancy. So single role redundancy where there is not a pool and it's identified as a non-essential role which could be disseminated around the team. Are you able to give some more information on
I think that's probably getting at what do you do if there's just a pool of one, which is fine if there is. If you do identify a single role where no one else carries out that role within the business, then that's absolutely fine. You're just letting that employee know that they are the only person in the pool, and that means that the consultation process will then be slightly different than what it would be if there were multiple people in a pool, because it means you don't have to establish a selection criteria, which James and I spoke about, and you don't have to carry out scoring because it's only that employee that's at risk. So the purpose of the consultation will be to establish whether there are alternatives for their redundancy, but you would still at the beginning of that have to try and agree with the employee that they agree that they're the only person that does carry out that role in the business.
Yeah, I'd just add to that, it kind of links to what I was mentioning before about the difficult questions, that you can't go into that process with a closed mind, that you can't have already made a decision, although it might seem on the face of it, it's an easy decision because it's one person in a pool of one. As Claire was saying then, they might come up with some kind of idea that mitigates it entirely, the need for redundancy. So even in those circumstances, yeah, still make sure you do a fair process for consultation.
If you have any further questions for any of today's speakers or for Kevin, who was unfortunately not able to be here for the Q&A section, please get in touch with the guys in the team and they'll be able to get back to you on that. So let's have a look at the time. It's bang on 11 o'clock, so perfect timing to finish. Just to say thanks to the three speakers for the great insight today. And just to reiterate that on the back of this, we will be sending out the recording to you. So again, feel free to watch it back or to forward on to any colleagues and friends who you may find it useful. Our next HR breakfast will be in December, and we will be sending out more details about the format and the date, time and theme for that a bit closer to the time. So thanks for your patience today with the IT issues that we've had. I hope you all have a great Thursday and we hope to see you again soon.